SJC-11644, Efrain Quinones v. Commonwealth.
Good morning, Mr. Rudolph.
Good morning, Chief Justice Gantz. Good morning, Your Honors. Paul Rudolph on behalf of the juvenile appellant, and with me is trial counsel Joseph Mulhern. As the Commonwealth recognizes at pages 15 to 16 of its brief, in order for this court to sustain this indictment against this juvenile, you would have to interpret the language in the youthful offender statute that requires that the offense, quote, involve the threat of serious bodily harm in violation of law as meaning the mere potential or possibility that this offense could lead to serious bodily harm to some as yet unknown individual. But that interpretation is flawed for three principal reasons. First, it is directly at odds with this court's 2012 decision in Washington W., as the Commonwealth acknowledges in its brief, which is this court's most recent and direct treatment of this very issue. Number two, possibility is not the meaning that we generally ascribe to the term threat when used in the legal context, particularly in a criminal statute, let alone the phrase used here, which is threat of serious bodily harm in violation of law.
But there's a sense in which you use the word threat to mean, you know, there's a threat of rain, there's a threat. I mean, in ordinary language, threat does have that connotation.
If you look the word up in a regular dictionary, the number 2 or number 3 definition is something along those lines. I concede that. But number one, that is not the way this court has ever construed that term in this statute. Number two, it's not the way we generally use the word threat in a criminal statute. Here, it's coupled with the language in violation of law. And also, even if there are alternative dictionary definitions to a term in a criminal statute that's not defined within the statute, the court would have to apply the rule of lenity and employ the term that is most protective of the juvenile. So yes, it is a possible meaning, an alternative meaning to the term in plain language, but that's not what the legislature meant here. And the third potential reason why, the third principal reason why this court should reject that interpretation is because if you adopted that interpretation, then any juvenile charged with this offense, and in fact many felonies, could be indicted as a youthful offender regardless of the circumstances of the crime, because many felonies like this carry the possibility that someone could suffer this type of harm. And that is not what the legislature intended, and it is contrary to this court's clear jurisprudence going back to Clint C., Quincy Q., and Washington W.
How do we know it's not what the legislature intended?
Well, I think one way you know that, Justice Lank, is because in drafting this statute, the legislature established 3 sort of different categories of juveniles who can be indicted. They all have to be between now 14 and 18 years old. It has to be a felony. And then either it's a juvenile who was previously committed to DYS.
So you're saying it has to be viewed in connection with the other alternative ways that somebody could be a youthful offender. That's right, because one of the alternative ways lists specific firearms offenses. And so for those offenses, the circumstances of the crime don't matter at all. If you're a juvenile between 14 and 18 and you're charged with one of those enumerated offenses, you can be indicted as a youthful offender. The legislature knew how to create a list of categorical crimes that could be subject to indictment, and they didn't include this one among that list. They could, they didn't. And so this court has properly always looked to the factual circumstances of the commission of the crime itself. And here, there's absolutely nothing about the factual circumstances of this juvenile's alleged commission of this crime that demonstrated a threat in the legal sense of serious bodily harm to any particular individual.
Do you think, this is a related question, but obviously the single justice looked at the bodily harm as injury to people who use heroin. And so the question is, A, do you think that, assuming, I get your nexus point, but put the nexus away, do you think that is a reason, that's a permissible interpretation of bodily harm in this context, or would you argue something? I'm not sure what you say about that.
Well, I think if you had a circumstance where an individual actually administered intravenously heroin to another individual, and that and the recipient overdosed and died, for example, not only would it be a manslaughter, arguably, but I would concede that under those circumstances, that juvenile could also be indicted as a youthful offender for distribution of heroin, which is the same.
So that was going to be my next question. Would this be different if it, instead of possession with intent, it were distribution?
Only if there was the actual, I think only if there was the infliction of serious bodily harm in terms of an actual overdose, or if there was some either explicit or implicit threat in meaning a communication or a declaration of an intent to do harm. I'm not sure what that would be under those circumstances.
So you would not read threat to mean, for example, a danger of?
No, I wouldn't, because that, again, that's real close to sort of the possibility. You know, there's the threat that there might be more snow this weekend. There's a danger or risk or possibility of it. That is not what the legislature meant. That's not the way we usually use the word threat in criminal statutes. And in fact, I think it's interesting if you look at footnote 8 in Clint C., which is a case that didn't really address these two competing definitions of the term threat. Clint C. was really addressing whether or not the offense itself had to contain as an element of the offense the infliction or threat of serious bodily harm. So the court in Clint C. wasn't really addressing this issue. But if you look at footnote 8 in Clint C., this court looked at a prior appeals court decision, Commonwealth versus Juvenile, which is 10 Mass Appeals Court 385, in which they did, Justice Cordy, the appeals court did use the language danger of harm when discussing the pre-existing transfer statute. And it's the same phrase, threat of serious bodily harm, that was in that transfer statute. And in footnote 8, I think this court is saying the appeals court wasn't particularly careful about the use of that, using that phrase, because the juvenile in that particular case didn't even argue that the facts of that case did not include a threat or infliction of serious bodily harm. So I think even back as early as 1999, this court was wary of utilizing that definition. And then in Washington W. in 2012, it's crystal clear that that definition cannot apply. And again, the Commonwealth acknowledges this in its brief, because in Washington W., the juvenile was indicted for a rape of a child. And the Commonwealth argued in that case that rape of a child necessarily includes the threat of serious bodily harm. The act of penetration itself always carries that threat, read danger. And this court rejected that. And this court said, no, you have to look to the specific circumstances of the case. And in that particular case, because the juvenile physically pushed down the child victim before the act of penetration, this court said that act carried the implied threat of harm if the victim resisted. So this court was utilizing the definition of harm that we usually use in the criminal context in Washington W. And the Commonwealth is asking you to essentially walk back from your decision in Washington W. And I would urge you not to do so, because I think it was correctly decided. It was consistent with the pre-existing case law. It's consistent with the legislative intent, as you can tell from looking at the entirety of the statute. And again, even if there is some ambiguity, the court would have to apply the rule of lenity.
Do we have any legislative history that sheds light on this?
I'm not aware of any legislative history going to this specific issue, Chief Justice Gantz. I'm not. But I really think that by rendering certain offenses categorically subject to youthful offender indictments, specific firearms offenses, the court was singling those offenses out.
I'm sorry, the court or the legislature?
Excuse me, the legislature was singling those offenses out for that type of treatment. The Commonwealth is saying...
With the view that the focus was on crimes of serious violence, which is why you include firearms?
Or the view that those might not be deemed sort of sufficiently violent in and of themselves, but they're so dangerous that they should be subject to indictment. I mean,
Sort of like what the legislature did after this court in the dangerousness statute did not include possession of a firearm as a dangerous offense, and the legislature added it as a named.
Yeah, and I think it's understandable the legislature considered this and said, you know, a juvenile carrying a firearm, even if they're not overtly threatening anybody with it, is a dangerous enough circumstance categorically that they should be subject to youthful offender treatment, which means potential penalties just like adults, whereas they did not make that decision for possession of heroin with the intent to distribute. I don't dispute that heroin's a dangerous drug. The officer who testified at the grand jury said that correctly, it's very dangerous. People can overdose, people can die, people can get very ill from it. But the legislature did not, at least has not up till this point, made the decision that it is so dangerous that categorically juveniles should be subject to being treated just like adults who commit this offense. And there is just nothing in the circumstances of this case that involves a threat. And again, I concede in my brief that there could be circumstances in which a juvenile commits this crime that under which they could be indicted as a youthful offender. For example, a juvenile who is selling heroin on a particular corner and says to another dealer, if you sell in my territory, I'll shoot you. Right? That is committing this crime and also involving the threat of serious bodily harm to another individual. I think that juvenile could be indicted for this offense. We don't have anything like that here in this case. So I would suggest that on the evidence presented to this grand jury, there was simply no evidence supporting a conclusion, supporting probable cause to believe that this juvenile inflicted serious bodily harm on any other individual or threatened to do so in the sense that we generally understand that word when used in a criminal statute. And as a result of that, this court should reverse the motion judge's denial of our motion to dismiss.
Now, pragmatically, imagine the possibility that you win. It happens sometimes. Mm-hmm. What happens with this particular juvenile?
The Commonwealth proceeds.
Can they still proceed? Is there still time in terms of his age to proceed with a delinquency complaint?
Yeah, I believe so. Getting the nod from trial counsel. He is now 18, is my understanding. But I think they can still proceed by complaint.
I can't remember. Was there originally a complaint and then the indictment, or there was never a complaint? I don't remember.
There was a complaint. Thank you. So, if there are no other questions, I will rest on my brief. Thank you.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. Your Honors, this issue has a sort of complicated history. My brother noted in footnote 8 in Clint C, it mentions that there was a 1980 appeals court case, Commonwealth versus a juvenile, in which the appeals court, after citing several different dictionaries, actually concluded that the sort of common understanding of threat was risk. And in fact, the juvenile took FAR, and this court then agreed with the appeals court, explicitly saying, we agree with the conclusion and reasoning of the appeals court, and need add only the following comments. The authority to transfer focuses on the question whether the crime charged is one that involves a threat of serious bodily harm. The crucial fact is that the crime involves a threat of serious bodily harm, not that the person charged intended such a threat.
Now, that was Section 61.
That was
and
Section
that was
61.
A different, that was when
Yes.
the judge was basically making the decision about whether or not to
Yes.
transfer. And the new section that we're dealing with doesn't have anything other than prosecutorial decision.
I would absolutely.
And that may be a difference in the reasoning that accounts for the definition of threat in Washington W.
I agree, Your Honor, that it's significant that it is a different statute. However, I would also argue that it is significant that at the time the legislature lifted this language wholesale from that statute, and at the time they created the current statute in 1996, this is what this court had told them that language meant. And a lot of things can change within the context of the statute, but the question of what does threat mean in common understanding, I would argue is something that sort of exists. It is what it is, independent of its context.
Washington W gives a different twist to what threat means.
Certainly, Your Honor, it does.
So,
I
perhaps overruling anything, impliedly overruling any prior definition to the contrary.
Certainly impliedly overruling previous rulings of this court. However, I would suggest that it is significant that at the time the legislature, whose ultimate intent of what to do with juveniles is what's at issue here, passed the statute, that was what they would have, based on previous precedent, understood the term to mean, and that what they ultimately wanted to write is the governing issue here in terms of how they wish to treat juveniles.
Now, if you win, and you sometimes do too, does that mean that for all practical purposes, every time there's a crime of possession with intent to distribute heroin, cocaine, oxycodone, it's a youthful offender?
Well, I think there's two different checks on that being every time. First of all, there's prosecutorial discretion, but second of all, it goes to the grand jury. They're not told that as a matter of law this does pose the threat of substantial bodily harm. They have to decide that for themselves. And I would argue that that gives a certain amount of leverage to them to decide if they really think this is convincing.
But if you're guiding them on the law, and the law is simply that the risk of a drug ripoff or an overdose is sufficient to provide a threat, isn't that always going to be the case? Whenever there is a dangerous, let's put aside marijuana, but the kind of dangerous drugs which do produce overdoses and ripoffs.
Well, Your Honor, I would argue there are two issues here. One is, can it go to the grand jury? And the other is, what evidence do we need to provide them with to enable them to determine that this does pose a threat of substantial bodily harm? I mean, I think that this court has said in its recent line of cases that the legislature intended to expand the scope of what currently fell under the statute, and I think that heroin is a very real problem, as I articulated in my brief. There's a lot of law on this that, you give it to somebody, it's going to be very likely very bad for them, sort of more than even a possibility. And drugs, I would argue, actually, unlike guns are obviously very dangerous, and you can kill people directly with them, but if you sell somebody a gun, they might stick it in a drawer. If you sell somebody heroin, they're probably going to ingest it.
But the legislature knows that as well as we do.
Yes.
And if they understood that, why would they not have done with possession with intent crimes what they did with firearms crimes and make it categorical?
Well, I would have a couple of arguments for that, Your Honor. One would be, as I said, I think that there is an argument to be made that when they used that phrase was defined in case law as meaning risk, and that would be covered under it. I think that you can argue that, in fact, there is more of a causation nexus with selling somebody heroin than with selling them a gun. And also that it's possible that they thought that this was a category they didn't want to give the grand jury latitude on, that they wanted to be clear that this was the only option for that, but otherwise it depended on the showing.
Can you think of any other statute where it's been in the legislature's mind, or somebody said it's been in the legislature's mind, we're going to leave this up to the grand jury? What we mean? I mean, whether or not to...
Well, it's an issue that has to be decided by the grand jury. I mean, I think that is...
No, but usually I think that statutes are written, with some sense of what they mean, not waiting until the grand jury decides whether to apply it or not.
Well, I think that I think it's a sufficiency analysis, and I think that a lot of the time, the grand jury also has to find that we present sufficient evidence of the age of the person, which is usually not actually up for much dispute in terms of the real world understanding. Okay. So they have a number of things are left to them That, I mean, you can have a case with overwhelming evidence of guilt and you still send it to the grand jury, and sometimes they'll issue a jury nullification.
But there's, if we use the meaning of threat as risk, is there any risk, any level of risk, a minimal risk? Is that enough? I mean, or are we somehow having to import a quantifier in this? You know, it has to be a substantial risk, a significant risk. I mean, minimal risk, is that enough?
I would not argue either that here there's minimal risk or that would be the standard. I think that threat does carry with it, as in the
So it's just sort of whatever this person, we don't have to look at what this person did or is alleged to have done, but it's enough to look at something general, and that is enough of a significant risk?
I think it depends on the crime.
Well, here, okay, he had heroin for sale. Let's assume that. But it's not so much anything other than what could happen if someone bought it, what could happen in the trade of selling heroin. See, these are general, rather than what he did, other than the element of the crime itself.
Well, I think the specific issue with heroin is that it's by its nature, it's a systemic societal problem, but that because of that, as the various cases I cite mention, there's a very strong inference that somebody is going to buy this, somebody is going to ingest it, and that it is known to be a very dangerous endeavor to ingest heroin. You can get addicted. You can die from it relatively easily. I mean, I think that this court it would be an option open to this court to rule that maybe you would have to have something about the purity of the heroin. I guess you could make it dependent on how likely is someone to die from this. But I think that the general idea.
Do you think I mean, most of the cases, you know, as from Clint C., et cetera, don't look at what is the crime, but what are the facts of the crime. Here we don't have distribution. I mean, even if I accept your point, we don't have distribution. We have possession with intent. That's the crime. So it hasn't been distributed to anybody. I mean, you still think we would still go to the risk
I think,
on these facts?
I think, Your Honor, that given what is known about the nature of drug distribution, that if you were selling something, I think that there could be a lot of evidence, and maybe you'd require us to produce this evidence at the grand jury, but that there will be a buyer, that this is not, you don't just sort of, if you can establish intent to sell, I mean, again, personal use is another matter, but if you can establish intent to sell, I think that it is entirely reasonable, if not almost compelled, to conclude that somebody will buy this if there is a market for this among people who will use it. I think there's a lot of data about the current huge problem with heroin addiction and people dying very frequently of bad heroin.
The statute was written in 1996, right?
Yes, Your Honor.
So that's actually a question I was about to ask. Thank you, Justice Botsford. 1996. So does it depend on what currently is a bad batch of some kind of drug that this then comes into play? So now it's heroin. What if it's some other drug next? And heroin, it's pure. People know how to use it. Illegal, for sure. Addictive. You're not suggesting, so that's one question. Mm-hmm. Does this change depending on societal, the drug of the day, the bad drug of the day? That's one. And the other one is, you mentioned, well, people get addicted. So anything that's addictive, regardless of whether you can overdose?
I think it would be required that you could overdose. Or at least, yes, that, I mean, coffee is addictive, but I don't think anyone is arguing.
I know.
Yes, but I don't think anyone is arguing that would be, I mean, I think that from the Commonwealth's perspective, the legislature is focused on the danger of the conduct.
Okay, so does it matter that it maybe wasn't so, the proof wasn't about its dangerousness at the time that this legislation was enacted, though?
No, Your Honor.
So does it change?
I think it could change. I think it would depend on the sort of crime and the nature of, I mean, I think that the fact that society has a problem with it now doesn't have any bearing on whether it will be really bad for a particular person who buys this batch. I mean, I think that being a heroin addict of one is just as dangerous to the person who's addicted as being.
Okay. So does this mean that you're saying that the legislature may not have had it in mind then?
I think
but it's still contemplated in a very general sense.
I think that that could be true. I think that the heroin manslaughter case may have actually preceded 1996. I can't remember, but I think that there's evidence in the case law that this was actually a very large concern going back quite a while, even though we currently have a particular wave of it. So I think...
I'm sorry, go ahead.
Oh, I was just going to say, I think in this particular case, there might well be reason to conclude in the case law that this is something that the legislature could have had in their mind. But I think that ultimately they're concerned about, is this person dangerous to, is this person acting in a way that's putting people in danger? And by that standard, you can go a number of different ways from there.
Your brother and you do have some common ground, as far as I can tell. That is, as far as I can tell, if you had evidence that somebody was selling heroin which was tainted with something else which was going to be poisonous...
Fentanyl.
Sorry?
Fentanyl.
My sense is that he would agree that that arguably would be a youthful offender, and if you were to mislead somebody as to the purity, so as to provide a really substantial risk, why would that not be enough? Why do you, I mean, here you don't have that. You don't have any misleading as to potency, and you don't have any evidence that it's laced with something else. Why would you need to go beyond what he's conceded to say, anytime there is heroin, period, it's enough?
I think that you could make a number of different determinations about where, I mean, I think that, I mean, I'm not entirely sure how to answer the question of, well, a higher standard of proof would have been enough, so why do we need to reach?
Well, I mean, his is
now.
situational. He's basically saying there could be situations which would be especially egregious, which would permit this crime under those circumstances to do it. Your argument, as best I can tell, would incorporate, I mean, this is a pretty generic possession with intent. So if this is okay, as far as I can tell, virtually any possession with intent involving heroin, at least, would be okay. And the question is, why do you need that in terms of the decision between youthful offender, moving? Why would that be enough to move somebody into an adult youthful offender sentence where you have the opportunity with egregious cases to do that?
I think that it's just a question of where you feel like the line is best drawn. I think that we agree on some things, we disagree on others, and that's why we're here. And it ultimately, I mean, I think that obviously you can say some sorts of conduct are more dangerous, but that doesn't make lesser forms of conduct not also dangerous, such that the legislature could have felt like this was a problem that might warrant treating these people potentially as adults.
Well, otherwise you would lose this case if you agreed.
That too, Your Honor. There are no further questions?
Right.
The Commonwealth rests on its brief.
Thank you for pinch hitting on this case.